everyone. Thank you for joining us today for this virtual classroom. It's really exciting to have the OCM, the Office of Cannabis Management, with us here today to be able to walk us through this program. But first and foremost, my name is Dr. Shonda Macias. I'm the CEO and the chairwoman of the board of Women Grow. I would like to thank our sponsors, Rooted in Good, for supporting Women Grow and our narrative. It's important to have those that believe in you. So today's discussion is of tremendous importance in the world of cannabis. New York has opened up licensing until the 18th. Yes, 1 week from those that are interested in entrepreneurship in a multi-billion dollar market. Today's guest, the OCM, is in New York, and we are so appreciative that they are lending their platform to have these discussions with Women Grow. So thank you again. For those that don't understand the role of the Office of Cannabis Management, let me brief you for a second. The Office of Cannabis Management in New York is the regulatory body responsible for overseeing the state's cannabis industry. Established as part of the Marijuana Regulation and Taxation Act, the OCM is tasked with regulating and implementing policies related to cultivation, retail, manufacturing, distribution, and the use of cannabis products in the state. Some of their key responsibilities include, like we said, licensing, issuing them to those that win, but also regulating those licenses. So what that means is setting standards for those to make sure they're compliant with the state laws. Also, the OCM enforces. They monitor and enforce compliance with cannabis laws, including regulations related to product quality, safety, and advertisement. And as we know, what we're here for today is the social equity initiatives that we're very thankful for. Implementing initiatives to promote social equity within the cannabis industry. This is something that Women Grow has been prioritizing and fighting for our rights. And today we have those that have been I would say, disproportionately affected by cannabis prohibition. Now is a good time to be a part of a billion-dollar industry. And we're so grateful that some of these provisions will include reinvesting tax revenue into these communities. OCM, what they're doing with us today is providing public education and outreach. So conducting public awareness campaigns to educate the public about cannabis laws, responsible use, and potential health and safety risks that are associated with cannabis consumption. You see, the Office of Cannabis Management plays a critical role in shaping and regulating the cannabis market in New York, ensuring that the industry operates within the framework of the law while addressing social equity concerns and promoting public health and safety. Let me provide a little bit more background for those that are new to this discussion. New York made significant strides in cannabis legislation, in particular with the Marijuana Regulation and Taxation Act. It allowed for the possession and the use of limited amounts of cannabis for personal use. The legislation established a regulatory framework for cultivation, distribution, and the sale of cannabis products. The MRTA aimed to address social equity concerns by promoting social equity applicants, prioritizing licenses for individuals from communities disproportionately affected by cannabis prohibition, and reinvesting tax revenue into these communities. It included provisions for expunging or sealing records of the past cannabis-related convictions and offering individuals a chance to clear their records and alleviate the burdens of previous convictions. The law outlined a system for taxing cannabis sales. The revenue intended to fund various programs, including education, drug treatment, and job training in communities most impacted by the war on drugs. The legalization allows for open access of cannabis products for adults aged 21 and older. Legalization can significantly reduce arrests and convictions for cannabis related offenses. Expungement of past convictions can also provide relief to individuals burdened by previous nonviolent cannabis related criminal records. It opens up an opportunity for entrepreneurs, job seekers, and investors in the cannabis industry. See, the Office of the Cannabis Management, they're important for us, for our community, to give us an equal opportunity, an equal handshake to be a part of a multi-billion-dollar industry. I hope you take their words and their pointers for this application that is due in 1 week very seriously and try your opportunity to have generational wealth. With much no further ado, I introduce you Tabitha from the Office of Cannabis Management. Thank you, Tabitha, for being here today.
Thank you for the warm introduction, Dr. Shonda, and for inviting us to speak today to Women Grow.
Thank you for having us.
Hi, everyone. My name is Tabitha Robinson. I'm the Director of Economic Development with the Office of Cannabis Management. It is a pleasure to be here today. I'm joined by my colleague, Osaze Wilson, who is a program specialist, and we will be diving into what the opening of the market means for applicants as well as for women-owned businesses. All right, let's get started. So in today's agenda, we're going to start with an overview of the MRTA. Then we'll talk a bit about the social and economic equity, the C plan, which I know a number of you were key stakeholders in developing. Then we'll turn to look at the adult use application and C certification. How do you actually apply? What are the benefits of applying? And what do you need as a social and economic equity applicant? We'll also offer a chance for live Q&A towards the end. So the Marijuana Regulation and Taxation Act is something that Dr. Chandra mentioned, and it was signed into law by the governor in March 2021. The MRTA created the cannabis law and amended existing laws. A couple of things that it did: it made it legal for adults ages 21 and over to possess and use cannabis. It expanded the existing medical cannabis and cannabinoid hemp programs. It created licenses for adult use cannabis businesses, which I know some of you are really interested in today. It also established the Cannabis Control Board and the Office of Cannabis Management to oversee the cannabis and hemp industries. It set requirements to create a more equitable adult use cannabis market. And we'll spend a good amount of time today discussing what those requirements are. And it defined 5 equity groups: distressed farmers, individuals from communities disproportionately impacted or CDIs, minority-owned businesses, women-owned businesses, and service-disabled veterans. The C plan, the law requires that the chief equity officer draft a C plan after receiving public input. The goals of the plan are to promote racial, ethnic, and gender diversity when issuing licenses, and the promotion of diversity in commerce, ownership, and employment. It is a living strategic document that will be adjusted and updated over time to reflect what's actually happening in cannabis in New York. Now, this C plan is really awesome. It is the first time that a state is forward-looking about its equity intentions and putting it down in paper. It is a tool by which the public can use to hold us as an agency accountable and to make sure that we are living up to the demands of the MRTA with equity. We went around the state and we held equity roundtables. The law requires that we receive, quote, public input when writing the social and economic equity plan. So we held roundtables, very small group discussions around the state. We met with about 400 New Yorkers who sat at literal roundtables and discussed what they wanted policy to look like, what challenges they might face in their existing business endeavors, how New York could address the inequalities and the harms from prohibition. We spoke about what consumers might want, what hopeful business owners might want, what the general public might want to see from OCM. And on the right, we have a list of topics discussed. As you can see, the number one topic discussed was community, which really speaks to the ways in which these social equity groups are thinking not just about themselves and not just about their own individual wealth, but also about generational wealth, right? Also about bringing their communities with them and helping them to prosper. We met with women-owned businesses. As I mentioned, one of the 5 social and economic equity groups, women-owned businesses. So we met with individuals and organizations that define themselves as representing women-owned businesses or as a woman-owned business. And we got really great feedback. Here are a couple of quotes that we received from around the state. People in the community trust legacy dealers. We should utilize them to make community connections. These are direct quotes. Another woman said, a woman-owned business is fully owned and operated by women, not fronted by men, right? We really took that to heart of making sure that we adhere to the spirit and the letter of the law. Third one, once you start putting in stipulations, they show and improving just what I've been saying for the last year. I lost the love of my life, my kids, I lost my son to this. This quote really gets at what prohibition looked like for this particular individual, and we know for many more. And lastly, your local weed person was so helpful to learning in places that are underserved by legal and medical dispensaries. Their knowledge is invaluable and should be promoted. And we took all of these notes and we started thinking about, okay, what does this mean for policy, right? How do we take these sentiments that exist within the communities that we believe will be women-owned businesses, and how can we make sure that our policies as an agency address those? Many of the women-owned businesses had very concrete recommendations. Here are a few recommendations that came up over time. It focused on access. It said, create a pathway for legacy operators to transition to the regulated market. Another one focused on business viability. Create opportunities for women to network and to share new developments about the industry. This includes creating a database that features women owners and their products. This was a really important theme that we heard throughout our discussions with women-owned businesses, that they wanted to collaborate, right? They did not see their participation in this market as one of competition, as one in which resources are so limited that if one business succeeds, then that automatically means another one doesn't. No, there was actually a lot of discussion around networking, around pooling resources, around supporting and uplifting one another. And lastly, there was a recommendation about education that we'll share today. I encouraged us to develop messaging and campaigns that empower and amplify women business owners across all sectors in the cannabis industry. This is also really important because oftentimes what you'll see across all states, including New York State, in any other industry is sort of equity is an afterthought, right? They build the industry and then they look at the numbers and they say, oh, wow, we don't actually have a lot of women here. OCM is trying to start the adult use market, focusing on the participation of women, of minorities, of service-disabled veterans, distressed farmers, and individuals from CDIs. We are starting with equity, and this recommendation really encourages us to get that messaging out there to make sure that hopefuls, right, potential applicants, potential business owners, potential supporters and consumers know that this is an industry focused on uplifting women. Now we're going to turn to talk about how we have taken some of those recommendations and how the C plan has sort of put it towards direct policy goals. The two-tier market. So the C plan has a recommendation to support the two-tier market. And the MRTA actually really pushes this forth. A two-tier market is a market in which the supply tier and the retail tier are kept independent of one another. What does that mean? That means that ownership has to choose a side, right? You have to either be on the supply side or on the retail side. Either you are a grower, a processor, a distributor, or you're a dispensary. Now, you can do a bunch of things on the supply side and you can invest amongst those supply businesses, but you cannot cross the tier and invest in a dispensary or an on-site consumption lounge or in a delivery business. And likewise, the prohibition goes the other way. So those who are on the retail side also cannot invest on the supply side. Now, there are a few exceptions, like the micro business license, which is modeled after the craft brewery model, and that's meant to be very small. And they're allowed to cross the tiers. They function as a vertically integrated business. Why did we create this two-tier market? The law is very intentional about this, and it draws a lot from the alcohol market. The goal is to promote an industry where businesses are driven by what makes sense for them. It's driven by profits, it's driven by their consumer base, and not by the needs of their investors. What you often see is in markets where there are not two tiers, where it's all one and you're allowed to invest across, the retailer ends up making decisions based upon what their investor on the supply side says, right? So not necessarily carrying the best product that consumers like, but because that product will offer their investor, who also happens to be a distributor, the best returns. If you think about the example in the alcohol industry, you might enjoy Corona beer, you might even enjoy vodka or wine, any spirit, any alcohol, you name it. There are no retail shops in the country with that name. Corona does not have an alcohol store. Vodka does not have an alcohol store. And that is the model that we are using here to build our cannabis, our adult use cannabis market, in which those two are kept separate and small businesses are allowed to thrive without one single player coming in and dominating, the way that you see in tobacco, for example. Here's another visualization of the two tiers. You see the supply tier licenses, you see the retail licenses, and again, there's no crossing. You have to choose your lane. And once you choose your lane, your investments are limited to that. And the investors from whom you can receive funding are also limited to that tier. True party of interest. I'm sure a bunch of you have heard about true party of interest. And what is it? I'm going to try and demystify it. In its plainest sense, it is a mechanism by which it's a framework that the government uses to keep track of who's attached to a license. When you think about ownership, what it means to own a license, there are many ways that ownership can play out. It might be the name that's on the license, but names are often, the name that's on the license might be a front, right? And we know that someone is actually behind it, pulling the strings. Who's controlling the purse might be a different answer from who owns it technically. So true party of interest really helps us understand, regardless of the structure of your company, who is running this company? Who are the true parties of interest behind this license? Now, every license applicant will be asked to provide the contact information for all of their TPIs. And each TPI will be required to then fill out a form. If you're an individual, then that TPI will fill out a personal history disclosure form. If they're an entity, then they'll have to fill out an entity history disclosure form. And all of that will take place in a secure portal that you can access on our website as part of the application. We are capturing, for example, not only the president or CEO of the business, but also who has very large shares of equity. We're also capturing, for example, who might be running the shots on the day-to-day. Those might all be three different individuals. Sometimes they're the same. But again, the goal is for the agency to recognize who is pulling the strings in this industry. And we created this framework, again, to really honor the two-tier market that I described earlier, to make sure that no single player or single players are dominating, right? This is a mechanism by which we can track that, make sure that everyone is sort of playing the same rules of the game, and you can't spend a lot of money to hire very expensive corporate attorneys who will corporate structure maneuver their way past these rules. So the TPIs will be asked to submit information like basic identifying details and contact information. We'll need to know about any previous convictions, sanctions, litigation, right? There are some lines in the law that, for example, if you have been involved in types of fraud, you're not eligible to be on a license or to be a TPI. We'll also want to know what are the other cannabis license affiliations of a TPI. Again, for example, there's a limitation on the amount of cultivation licenses that you can hold. Does someone own 50% of 20 cultivation licenses, right? That would be an issue for us because it means consolidation in the market. So we're using TPI to sort of gather that information. We'll also want to know what goods and services agreements the TPI has. Again, you might not call yourself an owner, but you could have a goods and services agreement that says you do every single thing that the license requires, right? So you would, for us, you would be captured in this TPI document. And there's so much more information about TPI on our website that you can access. All right, now let's dive a bit more into our social and economic equity groups and what this means for the application. What is a C applicant? A C applicant requires two things. One, sole control, and two, you have to be held by an individual or individuals that meets one of our five, at least one of our five social and economic equity categories. Those categories are communities disproportionately impacted, an individual from a community disproportionately impacted, minority-owned business, women-owned business, distressed farmer, service-disabled veteran. And we'll go into them a bit more, but those are the five categories. If you want to apply as a social and economic equity applicant, you must demonstrate that you fit one of those five groups and that you have sole control. In the next slide, we talk about sole control. Sole control is a set of requirements that make sure that you are in fact the owner. First requirement, ownership of 51% equity share in the business. At least 51% of that business has to be owned by you. And that ownership has to be real, substantial, and continuing. Secondly, you have to have the right to execute all material contracts. You cannot give that away. You have to be able to sign on your really important contracts and make those decisions. Third, you have to exercise the ability to exercise the authority to materially influence day-to-day business decisions, operations, strategic priorities, capital allocations, who's controlling the dollars, acquisitions and investments of the business. Fourth, no timed or triggered recusal provisions, meaning you can't say, yes, I, Tabitha, would like to apply as a woman-owned business, but according to the operating agreement of this license, I'm going to be kicked out in 5 years. I'm going to be kicked out in 6 months. Lastly, you have to have the ability to direct decisions, voting or otherwise, such that no other person may exercise or have the ability to control the majority of the voting rights. Put together, these five requirements for sole control make sure that the individual or individuals with that license who are applying the social and economic equity are in fact running the license. What we see time and time again in this industry, especially as states try to repair some of the harm done by prohibition, is that the more benefits that the state, any state, gives social and economic equity or gives equity applicants, the more people try and take advantage of them, right? The more that individual becomes a front person. They become the person whose name is on paper, but they don't actually control the license, which means that they're not actually the ones benefiting fully from legalization, from any profits coming in, right? So sole control is really making sure that you yourself, who is raising your hand as a C applicant, is in fact running the show. In this next slide, I'm going to pass it to my colleague, Osaze Wilson, and we will be available for questions. Thanks, Osaze.
Thanks, Tabitha. So, my name is Osaze Wilson. I'm on the social equity team with the Office of Cannabis Management, in the program specialist role. I'll be continuing to talk about the different C applications and the different C qualifying categories that are covered by the MRTA, and what a bit about extra priority and what that means for your application. So the C application and certification. As you're filling out the application for licensure, you will be prompted to, if you are seeking to qualify as a C applicant, you'll be prompted to fill out a C application. That is found in our New York Business Express portal when you're filling out the Universal Public application. The applicant can submit for multiple C certifications within the same application. If you are if you're seeking to be a woman-owned business and you also happen to have served in the military, you would qualify as both a women-owned business if you meet the sole control requirements, and a service disabled-owned business if you meet the sole control requirements. Both of those certifications can be seeked on this one application. When we receive the application, it will be noted that you have applied as a C applicant, so that once application window has closed, we can pool and randomize your application according to your distinct pool, your C certifying pool. What if an applicant has been deemed ineligible upon that review by our office? If for some reason there's a problem with some of your certification documents, or for some other reason we reason that your C status is potentially ineligible, we communicate with that applicant and essentially provide a 30-day cure period for an applicant to remedy the situation with amended documents or explaining documents towards their C certification. If the applicant does not provide the necessary documentation within that 30-day period, the application in its entirety is not considered, and that person would have to reapply in the next application window as a general applicant. So for the first C category, women-owned business, obviously this applies to this cohort of individuals that are gathered today, but some of the other ones will as well. So I'll explain this one and touch on the others. A woman-owned business is defined as having at least 51% of the business owned, operated, and controlled by a U.S. citizen or permanent resident who identify as a woman. We ask for proof of this certification either by the state certification for MWBE. Many people who already do business either as an independent person or as an LLC if you can go back to the next, thanks, have already sought some form of MWBE certification with the state. We still honor those certifications in this application structure. In addition, if you are new to business in general, if you are pursuing this license, this application for the first time, if this is really your first foray into owning something, we also accept a sworn declaration that says that the applicant's qualifications are true and accurate under the penalties of perjury under the law, essentially certifying that the applicant and the individuals that make up the applicant's ownership structure are women who are citizens or permanent residents, and who have ownership interest in the business seeking to qualify as a women-owned business under the cannabis law. So the two pathways is the state certified MWBE process, which many of you may already be familiar with or are currently stuck through. And then the other is through the sworn declaration that essentially attests, or an applicant attests to the fact that they are a woman-owned business, and they understand that they would be asking of certificating documents, ID, things of that nature, to verify whether or not that information is accurate. Next slide. So additional C categories in addition to the women-owned business. We also have distressed farmers. In this track, an individual can qualify as a distressed farmer if they demonstrate that they have sustained 3 years of operating losses from their farm. We ask that individuals or applicants who are interested in qualifying as a distressed farmer to submit their file tax forms demonstrating the gross cash farm income below $3,500,000, and has been disproportionately impacted by incurring operating losses due to low commodity prices and facing the loss of farmland. We ask that you prove the low commodity prices just by standard documentation showing the commodity matrix for various products that you are growing on the farm, and local rezoning documentation, meeting board minutes, all of that stuff related to redevelopment or rezoning that threatens your farmland would be accepted to prove that you are also facing the loss of farmland. The second track for distressed farmers is the track that recognizes small farm operators in a typically unrecognized field. So we define the term farm operator as a producer who is involved in making decisions for the farm operation. So that's not only limited by just the owner of the farm, it can also include a member of the owner's household who's involved in the farm operations, a hired manager, a tenant or a renter of farmland, a sharecropper, or a partner. And we ask those farm operators with, again, defined as a revenue of $3,500,000 or less, to submit any of the following, any documents that prove their relationship with the farm owner. That can be tax documents, pay stubs, an employment agreement, contracting agreement, rental sharecropping agreement, and has one or more members who is a minority group member, as provided by a sworn declaration. So in this track, what we're trying to capture are minority individuals who are involved in farm operations, who are traditionally unrepresented in or uncaptured in traditional farm ownership. We understand that these people play an essential role in farm operations, and as such, their expertise should qualify them to qualify as a distressed farmer in the C category. So this is our attempt to do that. Next slide. The other category that kind of dovetails with the women-owned business is a minority-owned business. Similar format, we accept both an MWBE certification track that is done through the state, and we also can accept a sworn declaration that the applicant certifies that they are a member of the designated minority groups, which include Black and African racial groups, Hispanic persons, Native American or Alaskan Native persons, Asian and Pacific Islander persons, and that with their certifying information, they understand that the penalties of perjury include, revocation, cancellation, or suspension of a license. Fourth C category is disabled veterans. Again, this is a similar pathway as we have done with the other C categories. An applicant doesn't necessarily need to currently own or be certified as a service disabled veteran-owned business within the state, but we do accept the state certification in our certification of your C status. We also accept the verification, a verbal attestation and proof of service and your service disabled discharge that's provided by the Veteran Services to qualify as a service disabled veteran in our C classifications. And lastly, the C category involving communities disproportionately impacted. This represents individuals who this refers to census tracts that have had a history of disproportionately high marijuana arrest. And we seek to certify individuals from these communities who have either have lived there for the past 5 years when the applicant was below the age of 18, or 7 years consecutively throughout the applicant's life. To certify this, we ask that individuals seek records that show where they lived in that region that is represented as a CDI by education records, mortgage, property deeds, government issued IDs, government housing records, things of that nature, vehicle registrations. And we also extend that information to include parents of applicants. Say if you were an applicant, or if you're applying and you lived in Bed-Stuy, which large parts of our CDI neighborhoods, and you were there when you were from the ages of 5 to 10, clearly you wouldn't have any DMV records. You wouldn't have any deeds unless you roll like that. With your name on it, showing that you have lived in those places, but your parents might. And as such, as long as you're listed as a dependent on those documents, they should be accepted as proof of living in a disproportionately impacted neighborhood. Next slide. Before I get to extra priority, I just wanted to reiterate that while an individual can register for or can seek qualification in any individual C category, an individual can also seek certification in multiple C categories as well. Life is intersectional, and I'm sure that a lot of these categories can be represented by individuals who meet the qualifications for multiple categories. And as such, we want people to feel unlimited in their representation of their application and who's going to be owning the business to us, so that we can fully understand who's at the helm of these businesses. And which leads me to extra priority. The idea of extra priority is one that we try to reflect on how we give benefit to review or to the timing of review on application. In order to qualify for extra priority, there are 3 things that need to be checked. An individual that has an application in with the office has to qualify as a member as a member of a community disproportionately impacted. So they would have to have a CDI qualification. They would also have to show that they have an income lower than 80% of the median income in which the applicant resides, the income of the county in which the applicant resides. And the third thing that you would have to prove is that you were convicted of a cannabis-related offense prior to the effective date of the MRTA, or has had a parent, child, guardian, spouse, or dependent who was convicted of a cannabis-related offense. We need all three of those in totality in order for you to qualify as extra priority. And yeah, I guess good transition. Why would I want to qualify as a C applicant? That you can go to the next slide. Sorry. So there are a number of benefits to seeking and qualifying as a C applicant. You, on its base level, there's a reduction in fees. Every application costs $1,000 to send in. The C applicants, and this is you seeking as a C applicant, not yet certified, you would have to the cost for the application is reduced by 50%. That reduction in application fees also reflects, if you're once certified, to a reduction in annual licensing fees in the license type that you're certified for. In addition, the C certification offers benefit in how we're going to be reviewing, or how your application is pooled for review. You will be pooled and compared to other like businesses. So it's necessary that if people are seeking C certification, that the information that they pull is accurate and is certified, because once you are seeking that information or seeking that certification, any non-certification, if you fail to certify as a C business, would result in your application being skipped over in the license pool that you're in as well. So all the benefit that you would go to that would be attached with seeking a C certification is thrown out the window if you fail to certify, if the office fails to see that you are a certified C applicant. Yeah, I think next slide. Okay, so the application is still open for an additional week. Our adult use application portal closes December 18th at 5 p.m. So this is really the last week for people to work on and seek application support. If you are interested and still are seeking that application support, I highly implore you to take a picture of this QR code or this bit.ly link here that is in blue, which is hard to see on the turquoise, but that will link you to our C chip intake form, which will help us link you with a technical assistance partner who is providing this assistance to people who are completing the application at this stage. Like I said, TikTok application closes December 18th, 5 p.m. Applications at 5:01 will not be considered. So, just fair warning that is a hard deadline. So there is still time, but please work on this urgently. And stay in tune, follow us on all the social media. You can email questions about the licensing process to AU licensing, LICENSING at ocm.ny.gov. You can also email the C team at CSEE at ocm.ny.gov for any C certifying related questions. With that, I think we're ready for Q&A.
Wow, I'm so excited. I think I'm gonna go do an application right now. Thank you again for giving us that information. There are women out there, Women Girls Reach is humongous. And for us, we're grateful that you can empower women and social equity applicants in this process. So thank you again for your service today, and also just sharing such a wealth of information. And I think when I think about empowerment, I think about small businesses. I think about opportunities in not only in the cannabis industry, but also ancillary businesses that are supported by the cannabis industry. So this is really a huge opportunity for New York, period. And I would definitely like to see the community from I would say from we call it illicit, but I think their legacy to legalization to actually have a solid part of being part of this multi-billion-dollar industry in just New York alone. So it's really exciting. And that leads into my first question, which I hope you can help me with, which is how complicated is the application since it's due in the next week?
Sure. The application is designed to be done DIY. You do not need to hire a consultant. You do not need to hire a lawyer. You can do it on your own. What I would recommend is you pull up the PDFs of the application. So before you even enter into the application portal, we have offered on our website PDFs of the portal. So you can go through, you can gather your documents, you prepare to enter the portal by knowing what each page will look like. You should run through those PDFs and prepare your documents. You can also go through our FAQs. We have a long list of FAQs. And if you have any questions that are outstanding, you can just do a Control F and type in the keyword. As you do the application on your own, that FAQ, which is available to everyone in the public, including any high-priced lawyer or consultant you might want to pay, will literally walk you step by step and say you need X, Y, Z. So it's very doable, and we've laid out all the steps for a DIY application.
That's amazing. It just leaves no reason why not to apply, which there's one other hurdle. How much is the application, and do social equity applicants get a discount?
Got a little glitch for you too.
Can you hear me?
You're back on now.
Okay. So the question was, how much is the application to apply, and is there a discount for social equity applicants?
Yeah, the cost of the application is $1,000, and the discount is 50%. So then your new fee would be $500 upon certification. The discount also extends to your licensing fee. So the licensing fee comes in once your application is approved. You got a license, it's ready to go, and just right before you open, you have to pay, say, for a retail business, $7,000, $7,500 for your license fee. As a C applicant, that comes down 50%. So it reflects for all the different license types on application and license renewal fees.
So, for example, I mean, that's great because I've looked at different applications across the nation, and they range from hundreds of thousands of dollars to tens of thousands. So this is pretty good for in terms of the average person actually being a part of the industry and having this opportunity. Now, there's another question in regards to real estate. So you have your application, but I think on the PDF itself, they make reference in some of the applications about real estate. How important it is to have real estate at this point in your application?
So at this point, it's not required at all. We had two application windows. We had one that closed last month. That one was the non-provisional licensing round. And it did sort of ask applicants who had their location ready to go to get their paperwork in first so we could process that. At this stage, the application window that closes on the 18th, which is next Monday, you do not need a location at all. If you're granted a license, you'll be granted a provisional license. That provisional license gives you 12 months to find and secure a location. Up to 12 months. You can take you could take much less than that. But you have the time if you need it. So location at this point should not be a barrier to entry at all.
I will add, if you are seeking a processor or a cultivator license, those are licenses that require you to prove that you have control of a premise. That can be captured by a conditional lease, by a actual lease agreement. So the provisional status applies to the micro business and the retail license, but showing control for the other license type is still a requirement.
Wow. This is exciting. And I think this is a very interesting question here. When we will be notified when we get the license, that's the first part. So we apply on December 18th. How long does it take to get notified?
Still TBD. We are working around the clock to finalize this process and get responses back as soon as possible. So we hope sooner rather than later, but definitely in the new year.
And the second half of the question was, okay, I have the license, and you talked about investors. Is there any state requirements that need to vet my investors?
State requirements that need to vet your investors. So that's a very broad question. I'm not sure how to answer. What I can say is, with regards to TPI, your investors, depending on the amount that they are investing and the nature of their investment, will have to complete TPI disclosure forms. We will use those forms to track their engagement across the industry. So if, for example, you have an investor that would like to take 40% equity in your business, and wants to do so and you're applying for a retail license and wants to do so in 10 other retail licenses, they would come up on our radar as violating our TPI rules. Now, the rules sort of differ in terms of what's an investor allowed to do by license type, but there are limitations that pertain to the investor. And we have all of this explained in our FAQ as well.
Wonderful. And then this is the last question. Are the RO licenses still available?
The RO licenses, referring to our registered organizations, which are our medical operators. The presentation that Osaze and I gave today focused on our adult use market. The medical market is a separate market and has an entirely different application process. That application window closes on December 19th. So one day after the adult use application window closes. And if anyone is interested in our registered organization program and applying to be a medical operator in the state of New York, you can find more information on the website. If you go to cannabis.ny.gov, there's a tab that says medical. You'll click on it and it'll take you right away to the application and anything else you might need for that.
Well, I think you've answered all the questions. You have provided us with so much information. I am just praying and hoping that everyone that's joined us today can take use of this information, apply in the state of New York, and start your cannabis business. So again, thank you for joining us today, and good luck with your applications. Also with the Office of Cannabis Management, we are grateful that you wanted to empower our community, and thank you again.
Most
Signing
certainly.
off from Women Girls.